For instance, the Supreme Court has held that, quote, mere speculation of harm does not constitute a compelling state interest, end quote. The court has gone on to say that, quote, a governmental body seeking to sustain a restriction on commercial speech must demonstrate that the harms it recites are real, and its restriction will in fact alleviate them to a material degree, end quote. And the DC Circuit has told the FCC that the intermediate scrutiny standard is, quote, more demanding, end quote, than the requirement of record evidence in the Administrative Procedure Act. In short, clear appellate precedent mandates that the Commission conduct a serious analysis proving that the harm is real before the agency adopts rules that restrict speech. In the past 2 years, both the FCC and the Federal Trade Commission have opened proceedings to examine the broadband market. In neither case did an agency determine that systemic market failure existed in the broadband space. So when faced with a First Amendment challenge to a net neutrality order shortly thereafter, could the Commission clear this high evidentiary bar? In addition to First Amendment review, any new rules would likely face challenges under the Fifth Amendment. The Fifth Amendment's prohibition on the taking of private property for public use without just compensation extends to circumstances where, quote, a regulation reaches a certain magnitude in depriving an owner the use of property, end quote. The DC Circuit has highlighted that, quote, the Supreme Court has indicated that it will find a per se taking when regulations result in permanent physical occupation of property, end quote. Regulating management of privately owned and funded broadband networks, which were previously unregulated, could be deemed a permanent physical occupation of private property that rises to the level of a per se taking. Because a network's capacity is limited, mandating a right of access to others could amount to a, quote, practical ouster of possession by the Commission. Under a slightly different angle of the takings theory, such regulations could also be struck down based upon the significant economic effect on the network operator and its investment-backed expectations. As we go forward, we should be mindful of these potential constitutional pitfalls. Now, this morning I've tried to flag a few issues and arguments I'm examining as part of our work on the National Broadband Plan and our Open Internet NPRM. I invite all parties to this debate to fill the record with detailed and substantive analyses of these and other constitutional, legal, economic, factual, and public interest issues. In the meantime, I truly hope that the Commission will seriously consider a different course, a course that does not carry with it the unforeseen liabilities new regulations are sure to bring. The FCC could forge a new partnership with the appropriate non-governmental collaborative internet governance bodies that have worked flawlessly on these issues for years. Working together, we could collectively shine a bright light on allegations of anti-competitive conduct and work directly with the established internet governance community to resolve controversies. This approach, coupled with strict enforcement over antitrust laws, could very well provide the benefits sought by proponents of new rules without incurring the unexpected costs of a new regulatory regime. After all, this way of doing business has worked quite well thus far. The internet has flourished because of its loosely knit, non-governmental, bottom-up governance structure. So in other words, if it's not broken, let's not break it. In the meantime, the best antidote to potential anti-competitive behavior is more competition. Let's hope that all future FCC policies encourage more competition in lieu of regulation and rationing. And I'm going to now go down to the front row and take notes, and I think you don't have to file ex parte, so I'm going to take notes on everything you say, everybody up here. And thank you so much for having me, and I look forward to hearing this debate if there's any time left. Sorry about that.
Thank you very much, Commissioner McDowell. At this time, I'm going to take the opportunity to introduce our panelists. Thereafter, they will have approximately 5 minutes to give opening remarks. We may have a couple of questions to the panelists after that, and then we want to get right into your questions. So we're going to have very brief opening remarks from the panelists. Our first panelist today is Kyle McSlarrow. Kyle began his tenure as president and CEO of the National Cable and Telecommunications Association in 2005. In this role, he is the cable industry's primary public policy advocate in Washington, D.C., and he represents the industry's interest before Congress, the FCC, and the administration. He was appointed in 2007 to serve on the President's National Security Telecommunications Advisory Committee. And prior to joining the NCTA, McSlarrow served as the Deputy Secretary of the U.S. Department of Energy. He holds degrees from Cornell University and the University of Virginia School of Law, and he wanted me to specifically mention that he's one of the founders of the UVA FedSoc chapter. Our next panelist is Gigi Sohn. Gigi Sohn is president and co-founder of Public Knowledge, a nonprofit organization that addresses the public stake in the convergence of communications policy and intellectual property law. She is a frequent speaker and frequently quoted in the national media on issues of communications policy. She also serves as a senior adjunct fellow at the Silicon Flatiron Center for Law, Technology, and Entrepreneurship at the University of Colorado. She is also a senior fellow at the University of Melbourne Faculty of Law in the Graduate Studies program in Australia. What a great gig.
Long commute.
She holds degrees from Boston University College of Communications and a law degree from the University of Pennsylvania Law School. Thank you for being with us today. Our next panelist is David McIntosh. Former Congressman David McIntosh is a partner at Mayer Brown, and he focuses his practice on the areas of government affairs. His extensive government experience includes stints in both the Reagan and the first Bush administrations, as well as service in the United States House of Representatives. He has worked for a tax coalition on AMT reform, and during the Reagan administration, he served as special assistant to the Attorney General and as a special assistant to the President for domestic affairs. During the first Bush administration, he served as executive director of the President's Council on Competitiveness and assistant to the Vice President. He holds degrees from the University of Chicago Law School and Yale University. Thank you for being with us as well. Our last panelist is Professor Marvin Ammori. He is a founding faculty member of the University of Nebraska-Lincoln College of Law's Space and Telecom LLM program. He is the former head policy lawyer of Free Press, which is a nonpartisan media and internet issue advocacy group. He is also a fellow at Yale and Georgetown Law, and he holds degrees from Michigan and the Harvard Law School. Let's give a warm welcome to our panelists before they make their opening statements. Take it away, Kyle.